Hey everyone, Michael here, co-founder of Studicata. Just want to officially welcome everybody to our constitutional law course. This has been one of our most requested courses, and I think I understand why, right? Typically, in a constitutional law course in a law school setting, students are going to be subjected to all kinds of historical and theoretical, hypothetical conjecture, right? And it often provides little framework into how to actually apply constitutional law principles to fact patterns, right? It's often disorganized. So constitutional law is just one of those subjects where I feel like at Studicata we can really provide a lot or impart a lot of information that will be helpful on exam-like fact patterns, right? Because we're really going to focus on the application step by step of constitutional law principles to fact patterns and really try to provide a big picture framework, how to think about fact patterns, how to approach it from a big picture perspective. Once we understand all the big picture stuff, then we can really move in and look at each principle, each analysis, and how to apply that to fact patterns that a student would be likely to encounter on an exam, right? So we'll get into it all. In this video though, we really got to focus on all the big picture stuff, right? We got to think about how to approach a constitutional law fact pattern, a lot of issue spotting techniques, and what to think about as we approach a constitutional law fact pattern, right? And so while I do want to avoid a lot of historical context, right? In my constitutional law course, we spent maybe the first 5 weeks, I would say, really studying the Constitutional Convention, right? It was like a big history lesson, and everyone was just looking around at everyone like, what are we doing, right? So I'm going to try to sum that up in like 2 to 5 minutes here, depending on how quickly we can move. But I do think it's important, right? If you're going to make a constitutional law course, you have to start at 1776, right? So if you'll bear with me for a minute, let's go back to 1776. As we talk about this, it'll kind of help explain the structure of the Constitution, right? Articles 1 to 3, 4 to 6, and kind of the Bill of Rights and how it all fits together. You know, why the Constitution is structured the way it is, and kind of why that's actually the same way we approach a constitutional law fact pattern. It all goes back to 1776, right? The summer of 1776, there's a lot going on in North America, right? Obviously, the colonists, against all odds, have successfully rebelled against the British Kingdom, right? They've pushed back British forces and were ready to declare independence from the tyrant King George. Right, in the summer of 1776, Thomas Jefferson is asked to draft an actual Declaration of Independence. He does this, and the Declaration of Independence that we all know and love is officially approved on July 4th, 1776, which most consider to be the birth of our country, right? The United States of America. And so from here, though, it's important to recognize from 1776 to 1777, there's a lot of uncertainty, right? A lot of unrest, a lot of kind of chaos, if you will, because the Declaration of Independence doesn't set up really what the United States is to look like. It's more of just a Declaration of Independence. It's explaining to King George why we're piecing out, right? Why, you know, it's really an airing of grievances. This is everything that we feel like we were wronged on, right? Things like taxation without representation, the gross infringement of what were, civil rights, what were considered to be inalienable human rights, right? All of this stuff is laid out, and we're like, hey, this is why we don't like being ruled by the tyrant King George. This is why we're declaring independence. But it didn't really provide a framework for what the United States was actually going to be moving forward. And really, it declares 13 independent sovereign states, right? And so from 1776 to 1777, this creates some uncertainty and a little bit of chaos, right? Because the different colonies, the different states are kind of starting to do their own things, and it's unclear how it's all going to be unified as a true united front, right? The United States of America. So to deal with this and kind of establish a plan for the future and to frame the government, right? How is the United States going to govern itself, right? We have the Constitutional Convention in Philadelphia in 1777, where representatives from the different colonies come together to debate what our government is going to look like. How are we going to frame our government for the future of the United States, right? We're going to have a democracy, a republic, this, that. What's it all going to look like? So this is debated for many months, and eventually, right, we land on the U.S. Constitution. But in doing so, right, it all comes down to basically one core principle, right? There was one big problem that the framers really had to grapple with. And James Madison, who's considered kind of the father of the U.S. Constitution, has a really elegant quote on this where he talks about angels and men and government. And it's this really great, elegant quote. And it all boils down to kind of the problem. And I'm not going to read the exact quote. We can post it below the video. But what he's getting at is the problem here in setting up a government of men that is designed to govern other men is twofold, right? Number one, we understand that we have to create a government that has enough power to provide for the general welfare of its people, right? We have to vest enough power in a government that it can provide for the general welfare of its people, right? This is important. If we have a government but we don't give it enough power, right, well, it can lead to chaos and anarchy, right? Where we have a government that's too weak to provide for its people. Not a good result. On the other hand, if we give too much power to the government, especially if we vest too much power in any individual or entity within the government, right, we can end up with a tyrannical regime, which would look like something that we just fought so hard to get away from in King George, right? The tyrant King George, who we're just getting away from. So you have this competing interest of we want to establish power, we want to give enough power where we can provide for the general welfare of our people, but too much power and it becomes a tyranny, right? Where we have a dictator ruling like a king. So this is the problem that they grapple with. And so their solution is really threefold, right? Where number one in the Constitution, in Articles 1, 2, and 3, they say, okay, well, the first thing we have to do, right now we have 13 independent sovereign states. We have to set up a centralized government, something that's going to unify all the states together, right? We need a centralized government, what we all know and love today as the federal government. So Articles 1, 2, and 3 are all about setting up the federal government. Now, again, if you're going to set up a centralized government, the first thing the framers are thinking, hey, look, that already starts to look like a monarchy, right? Where we're saying we're going to have one central power, right? That's going to make the decisions. That's not good. So how do we balance that? Okay, well, we're going to separate the powers, right? We're going to set up one centralized government, right? The federal government, but we're going to separate those powers within the federal government. And at the same time, we're going to separate those powers. We're not going to do away with the state governments, right? Articles 4, 5, and 6 really deal with, okay, look, we're going to set up this central federal government, but we're not going to do away with the state governments. We're going to keep the state governments, and we're going to keep the state governments strong. So we have to deal with now two layers of government, right? What's the relationship between the federal government and each state government going to look like, right? This is Articles 4, 5, and 6. And finally, the third prong is this idea of individual rights. Okay, well, we're setting up one central government, right, that can provide for the welfare of our people. It's going to organize everything. It's going to unify us with one central government. We're going to make sure that we separate the powers within that government, and we're going to keep two layers of government. We're going to allow the states to have government, and we're going to find out a way to make the relationship between those states and the federal government work. But still, we also want to make sure that our people, our citizens, are protected, right? The Declaration of Independence, and one of the most famous quotes in American history, right? Where Thomas Jefferson writes that we believe all men are created equal. And all men have certain unalienable rights, of which include the right to life, liberty, and the pursuit of happiness, right? This is one of the core reasons we left, right? We're declaring independence from the tyrant King George. We believe in certain inalienable rights. So the framers knew, hey, look, we're going to set up all this government to separate powers, to create two layers, to have a federal government and a state government. But at the same time, we have to protect our people, the individual rights. We have to establish certain inalienable protections that the government cannot infringe on in any circumstance, right? And this is how we end up with the Bill of Rights, right? Due process, equal protection, free speech, religious freedoms, freedom of association, right? Some of these are in the Bill of Rights, some of these are in different articles, but the idea that we're going to provide a lot of individual protections as well for our people, right? So the approach to the problem James Madison lays out is really a three-prong approach, right? How do we create a government that has enough power to provide for the general welfare of its people, but doesn't have too much power where it can become tyrannical or tyrannical, right? This is how we do it. We have the power of the feds established, right? We establish a federal government, Articles 1, 2, and 3, but we separate those powers, right? Article 1 vests the legislative power in Congress. Article 2 vests the executive power in the president. And Article 3 vests the judicial power and the Supreme Court and the federal court system. Articles 4, 5, and 6 deal with the multi-layers of government we now have between federal government and state government. And finally, to protect the individuals, we have the Bill of Rights and some other clauses included in the Constitution to make sure that those inalienable rights, all men are created equal, right, that Thomas Jefferson referred to in the Declaration of Independence, that we make sure we are providing protections for the individual, right? So we don't end up with, right, a situation where somebody says something about the king doesn't like, and the king locks that person up or has them executed, right? We avoid that by establishing inalienable rights, okay? So this is the framework of the Constitution, and this is why it's set up the way that it is, right, from the historical context. So why does that matter for us today as law students approaching constitutional law fact patterns? Well, typically, right, as you approach a constitutional law fact pattern, you're going to be able to bucket each issue you encounter in one of these three categories, right, which we're going to call power of the feds, federalism, and individual rights, right? Power of the feds, the main issue here is, does the federal government have the power to take this action? So if you're looking at a constitutional law fact pattern and you see the federal government taking an action, right? That could be the president signing an executive order. That could be the Supreme Court issuing a ruling. That could be Congress passing a law or presenting a bill to the president, right? All kinds of federal actions, government actions could be taken, right? On a fact pattern, if you see the federal government taking any action, you have to ask, well, does the federal government have the power to take this action under Article 1, 2, and 3, right? Remember, the Constitution, first thing they do, first article, Article 1, 2, and 3, they set out the powers of the federal government, where the framers of the Constitution are saying, here's what Congress can do, here's what the president can do, here's what the Supreme Court and the federal court system can do, right? This is all being laid out in Article 1, 2, and 3. And of course, some of this stuff is broad. They don't say every possible situation that could happen and what to do in every situation. So through case law, we establish certain constitutional principles that we're going to apply as well. But the idea is, right, anytime the federal government is taking an action, we have to ask the question, well, do they have the power to take this action? Because if they're taking an action that they don't have the power to take, right, well, that means it's unconstitutional. They're not allowed to do that, right? That will be the conclusion we get to in our analysis, right? So that's what we're thinking about with power of the feds. And the big fact patterns we're looking out for, right, would be Congress passing a law, the president taking any kind of action, right? Negotiating a treaty, signing an executive agreement, right? President taking any kind of action, right? We would ask, does he have the power or does she have the power to take this action, right? And same with Article 3 in the judicial power. If the Supreme Court or any federal court is deciding a case, hearing a case, issuing a ruling, issuing an opinion, right? If we see a federal court or the Supreme Court taking any kind of action, we have to ask under Article 3, does the court have the power to take this action? Right, so this is our first bucket, and this is what the first third of our course is going to focus on, the power of the feds, right? Once we finish our discussion of power of the feds, we're going to talk about federalism, right? Which explores the relationship between the federal government and all the different state governments, right? This relationship between the nation and states, right? This is what federalism is all about. And this is kind of what is established in Articles 4, 5, and 6 of the Constitution, although we'll see some overlap in different areas, right? But here, the main issue is going to be any time on a constitutional law fact pattern we see a state government taking an action, right? Again, it could be issuing an opinion. A state court is issuing an opinion. A state legislator is creating a law, passing a law, right? Any state action, we have to ask, is this state action unconstitutional due to a conflict with the feds, right? Constantly, and when we have these two layers, remember the drafters, the framers of the Constitution set up two layers of government, and they knew that there was probably going to be some tiffs, some conflict, some struggle between that federal government and all the states, right? How do we deal with these potential conflicts? That's what the discussion of federalism is going to be. And usually the issue is whether the state action is in conflict with the feds. Because if it is, whether that's direct or indirect conflict, we're going to usually find that that state action is unconstitutional, right? And so we'll talk about that in some detail. We'll overview it. That's what the second third of our course will be on. And then finally, we'll get to individual rights, where our main issue is going to be, does the government's action infringe on an individual's constitutional rights? Typically, this is going to present itself in the form of either a state government or a federal government passing a law, right? They're going to be passing some type of law, and the question is going to be, does this law infringe on an individual's constitutional rights? And here we're going to think about due process, equal protection, free speech, religious freedoms, all these other individual protections, right? But that's the big picture. Those are our three main issues. And really, 9 times out of 10, we're going to be able to pretty easily bucket a constitutional law fact pattern into each one of these categories. So as you approach a constitutional law fact pattern, especially if you're looking at an essay, you really want to, as you go through that essay, try to put each paragraph or each sentence of that essay in the right bucket. What are we talking about here? What's going on? What are we trying to figure out? Are we trying to decide whether the federal government has the power to take this action? Are we dealing with a potential conflict between the state government and the federal government? Or are we dealing with a possible issue of somebody's individual rights being infringed on? Right? And it is important to note here, if you are a law student currently watching this video, some law schools break this up into multiple semesters, right? At a lot of law schools, you might do these two subjects, right, in your first semester, and then you'll do individual rights in your second semester. Right, this is a pretty common structure I've seen, where you'll do kind of power of the feds and federalism issues in your first semester, and then the second semester you focus on individual rights. I've even seen some law schools that break out First Amendment into like its own course. So you do like a constitutional law course, and then you do First Amendment free speech separately, right? So different law schools kind of break up the courses differently. But also you're going to have a lot of law schools that just have one constitutional law course where you have it all together. So obviously, though, if you're in an individual rights semester, you could fast forward to that section of the course, whatever you need to do, right? Just worth it's note worth making, right? But anyways, I think from here, if we kind of understand how the Constitution is framed, why it's framed the way it is, and kind of the major issue with each section, right, of the Constitution, and the main issue we're really thinking about, right, for each bucket here, we can briefly overview all of the topics we're kind of going to cover in each one of these categories, just to kind of give you the big picture of where we're going. Right now, it is worth noting again, all of these subjects you see. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.